Ladies and gentlemen, before the start of deliberations on today's topic, let me have the privilege as the president of Nissmat to introduce this international institution. Established in 1990, it has now become a think tank organization with association of more than 90 experts and scholars on various subjects who provide inputs to us. Our forum has conducted a number of webinars and interactive sessions which have received massive response. I am sure our session today would be of great interest to you all. Thank you.
Hello, good morning, good afternoon, good evening. I am Kashiana Singh, and I'm a moderator for Nissmat International, calling today from North Carolina in interview with Mr. Cpal Singh. The subject of our discussion today is right of private defense or right to defend oneself. And introducing Mr. Cpal Singh is both my privilege and my pleasure. Mr. Cpal Singh, President of Nissmat, former IGP Punjab Police and Rapid Action Force, Honorable Director CAPSI. He is here with us today to speak to us on this very interesting as well as critical subject. Welcome, Mr. Cpal Singh.
Thank you, Kashiana. Thank you for the introduction. Thank you.
Absolutely. Well, if it's okay with you, sir, without much ado, I'd like to get started with our discussions and go through a few questions one by one. I do look forward to this being a really enriching and enlightening discussion, both for me as well as for our listeners. Are you ready to jump in, sir?
Yeah, carry on.
All right, let's start with the first question, which is very straightforward. Again, a reminder, the subject of our discussion today is the right of private defense. Sir, it is the duty of the state, as it said, to provide protection to its citizens and the right to property. If that's the case, then what is the need to have legal provisions of right of private defense or self-defense? What's the need?
A very pertinent question. Peace and harmony in any state or any society are essential for development of the society. Security environments are today worsening day after day. State security apparatus is inadequate. There's no doubt that it is the duty of the state to provide security and protection to its citizens. But somehow or the other, to protect the life and property of the citizen, the state cannot keep a watch on each and every individual, each and every citizen. Further, there can be situations in which the state cannot help a person and reach immediately when his life and property are in danger. Further, as far as India is concerned, the strength of the police force is much inadequate compared to the laid down strength for the UNO. UN has recommended 222 persons per lakh of population. India's sanction strength is about 181 to 190, while the actual strength is 152 per lakh of population. Further, this 152 is also reduced because of the vacancies, because of the training courses, etc. Actually, available strength is about 130 to 135 per lakh of population, which is absolutely inadequate to meet the need of each and every citizen at the time of danger. So there has been a proposal to revise the Police Act also and revise the strength, but somehow or the other, these proposals are pending in the government and they are yet to be cleared. Now, under these circumstances, if a person has to repel an attack, if he's attacked, or a person is an imminent threat of an attack from somebody, or a person's loved one is under attack, or his property is in danger, then the right to private defense has been provided as one of the safeguards in the Indian Penal Code. This idea is, in fact, absolutely commensurate with any criminal law. It has to provide the citizens a right to defend themselves. And Indian law provides this right. That is why the Indian Penal Code provides this right, and there's a framework under which various duties are elaborated in the Indian Penal Code.
Mr. Cpal Singh, that was extremely interesting. Your background of the UN and some of the details you've given us about the legal provisions under the Indian laws. Before we summarize this section, though, I want to share with you a quote that I read about the Indian provisions, and I think it's section 96, which says the following: nothing is an offense which is done in the exercise of the right of private defense. Right of private defense cannot be said to be an offense in return. I find that to be an extremely interesting quote.
No, I'll go from there.
Yeah.
The section 96 gives the right of private defense in general, while section 97, the scope of right to private defense is defined. In this section, it says the right includes the use of action that is, very important the word, that is proportionate to the harm feared to be caused to you. You can repel an assault, you can repel an attack, you can repel an offense against you, but the offense for causing counter action, you should not go beyond the expectation as to what harm is likely to be expected by you. Then section 99. This section defines actions that are not subject to private defense. That means some people may be insane, or some man may be intoxicated. You say it's not, but you are entitled for right to private defense against such persons also. So long the right to private defense is exercised in good faith. And third, if there is any act authorized by law and acts performed with the permission of the person affected, some other individual is there and he is with you, and that person gives you permission that I am under danger, you please save me. You are supposed to save him because you are a citizen and he is a citizen, he is by your side, you are supposed to save him. Then there is a section 100 which addresses circumstances where the right of bodily defense goes up to inflicting death. How far you can go. Section 101 again addresses circumstances in which the right to private defense can be bodily inflicted up to death, etc., and in between whatever other injuries are caused.
Sure.
Rightly, under 106, exactly the one, the action, the particular section, death, is still abbreviated in 106, the section about death. The section defines and deals with the right of private defense against a death assault, deadly assault. And you are under deadly assault, then you can exercise the right of private defense and you have a reasonable apprehension of his causing death to you, or his causing grievous hurt to you, or his causing hurt or death to another innocent person who is by you. So such cases, section 106 elaborates. So from section 96 to 106, it elaborates various degrees and various types of sections, various types of acts against which you can exercise the right of private defense. So, but there are certain limitations.
Yeah, exactly. I was going to come to the question about limitations, but let's go there in a second. Can I ask you another question before that, which is, could you just spoke about the death and the need to defend the neighbor, the innocent party, right? Your partner, whoever else is with you. But in what circumstances, or could you give us examples of circumstances where the right of private defense allows the death of an offender?
The right to private defense is a very, very important aspect of the Indian criminal law. It is not an absolute right. Yes. That is important. Don't consider it as an absolute right. in order to prevent the misuse of this right, that you should not misuse the right of private defense, there are certain limitations which have been imposed by law upon the individual who is acting as a right of private defense. These limitations ensure the force used for self-defense is reasonable and proportionate to the threat. The force used by a person, the right of private defense, is reasonable and is proportionate to the threat faced by you. And if it is understanding is clear, then these limitations should be adhered to. In this case, the amount of power used must be proportionate, applies only while the danger exists. Now, this is important. Supposing somebody attacks you and you are given a counter, and after that you pursue, he has gone away. The danger is existing. That is, threat is not only imminent, but the threat is existing. Then only you can exercise. This is another very important limitation upon you. The individual exercising the right to private defense must have a reasonable conviction. They must have a reasonable conviction. Yes, he is likely to cause hurt. He has a pistol, he has a lathi, he has what weapon he is attacking it. So there should be reasonable conviction to counter that attack. The right to private defense does not include the use of deadly force unless there is a threat of death to you. Tomorrow somebody comes with a lathi and you fire at him and kill him. No. There should be reasonable conviction in your mind that he is likely to cause a serious bodily injury to me, or he is likely to cause my death.
And sir, if I may interject you for a minute here, just to make sure our listeners can absorb the point, I was wanting your confirmation that the extension to causing death, right, for in the right of private defense occurs in the cases of robbery, theft, house stress. Is that true? Is that where you were going with your description? Okay.
Yeah, certainly. Because you see, you don't know. That is again, somebody is coming by house break to you. Somebody is coming for theft. It's all right. You are not to use the force. But if in the process of undertaking or undergoing or performing his act of action, he takes out a pistol while committing a theft, then the right to private defense immediately after causing of death. Otherwise, right of the defense will not be there for defense. Because he has come for committing theft, you have to respond so long the threat is only of theft. But if the theft transgresses,
escalates,
and it goes beyond that, then the right to private defense will come also for death. There must be a absolutely reasonable conviction, I've used the word earlier, that it is likely to cause you a serious injury or is likely to cause you a death. The right to private defense does not include the use of deadly force unless there is a threat to death for you or serious bodily. I have repeated many a time. In instances of imminent mortality or serious bodily injury, now the person using the right of private defense must not act in a cruel or next limitation. He must not act, the person using the right of private defense must not act in a cruel or absolutely unusual manner. And since I have a right of private defense, you become cruel yourself. You follow him up to his house. He has gone away. The right of private defense is there so long the right is there, so long the threat is existing. He has gone home. You want to take a revenge. You follow him and kill him there. And you say, I have gone for right of
that is not under the right of private defense.
You cannot be cruel.
Yeah.
And in that case also, must not act in a cruel or unusual manner and must not think that you are taking a revenge for certain offenses which he has committed earlier. So therefore, the person using the right to private defense cannot use the right to justify preemptive strike. Before he strikes, you kill him. You say, no, preemptive strike, you have killed him. No, I expect it. No, that is also not given to you. Self-defense law mandates certain conditions. Imminent threat, first is, the threat should be imminent, must be immediate and impending. leaving no reasonable doubt in your mind that you are under attack. It should be proportionate. Number two, there should be reasonable belief and conviction. Then extent of force. To what extent? So these are certain conditions laid down which you have to exercise and keep in mind before exercising the right of private defense. Exceptions to right of private defense are there, but cannot be used to accept the use of force in such instances where there are exceptions. There are certain exceptions also laid down under law.
Why don't we just hold our thought there for a minute, sir? If I can conclude in a nutshell what I heard you say, two keywords came across that I want to make sure our listeners can capture. One is the concept of proportionality, and the second is the concept of reasonable apprehension. I know there are a few limitations that you listed out, but these two seem to be important keywords for a layman's terms.
You're right, but personality means the offender.
No,
offenders.
Proportionality. Proportionality is what you had mentioned.
Correct. No, there is certain points which we must keep in mind. That is that this right is not for revenge, as I mentioned earlier. Not taking a revenge, but towards the threat and even in danger. That's again and again. If you want to take a revenge, you say, no, he had come from so-and-so date, he had attacked me. No, after 3 days, you go and attack him. No, that is not allowed. That is not the law. That is not the Indian law. Indian law lays down that condition. But the problem in such cases is that these conditions, where they say it mostly is a subjective on the person who is using the right to private defense. He has to go to the, if supposing somebody drags him to the court of law and says, no, he is used like this, you have to be very careful. Already, if I am dragged to the court of law, I should not be guilty of being preemptive in my time or being killing him for the sake of a revenge. So this is a very important section, and various legal provisions have been explained by the courts of law from time to time. But by and large, that does not, one point again, it doesn't restrict, because if the right of private defense cannot be used and everyone is under inhibition, whether I should use or not, then there's no use. Correct. If he is using it for a conviction, it's only for the sake of making you realize, the person who is using right of private defense, make him realize as to what extent he can go. But law is, the courts have been quite liberal in understanding. There have been no restrictive clauses put. They have understood that sometimes you have to act, and it may be a little excessive. But that doesn't mean that proportionate, mean that 4 to 4. If he attacks you and with a deadly weapon and you are not killed, still you can kill him. Attacking with a deadly weapon, is likely to cause your death, so you can. Similarly, if somebody is there and he is with you, is your loved one, or is your innocent person by your side, he is being attacked, you can certainly act on the right to private defense.
Understood.
Because otherwise there is right of private defense, the security of the state, the help to the law enforcement, that will vanish if we start having those restrictions under the High Court judgment. But wherever they find that intention of the right of private defense by a person is different than actually the right of right, then of course the courts step in.
Yeah. However, it's not. Thank you. That makes complete sense, and your explanation of the different sections is very helpful. However, like you just said, the right is not absolute either, right? Yeah, it's proportionate, it's not absolute, and it's based on apprehension of threat. Let's shift our discussion a little bit to the international scenario. I know we are focused on the Indian Penal Code. However, we know this is a global situation. Could you throw some light on what is the international legal position regarding the right of private self-defense?
It is a very, very pertinent question again, because some of the countries have the right of private defense in the statute book, but most of the countries earlier did not have. For example, USA, UK, these countries did not have this sort of right of private defense. But after the terrorist threat, last terrorist, not the terrorist execution of the threat on the TARS, after that, the USA has changed its statute book and got it approved by the international law that if there is an imminent danger, supposing there is a threat from a terrorist, now the terrorist has not attacked you. You see, here the right of private defense can be used, right of attack, because there's an imminent danger. We are assessed that this terrorist is going to have is an imminent danger to the state, so you can attack. That means it's a preemptive measure before the attack is executed. So they have gone to this extent, and they have said, all right, and I'll refer to, for example, one or two instances to make the position more clear. After the World Trade Tower, the USA has gone to the extent of getting approval of the UNO and also of its own statute book that even if there is an imminent danger, then you can exercise the right of private defense or right of defense. Killing, for instance, may not be considered a criminal act if the perpetrator has a strong belief, when you have killed him, has a strong belief that there is imminent danger of death or serious violence or serious assault or aggression or killing going to be mass-scale killing. That is mainly referred to the terrorists. So there is no question, right? Or you wait, they come, then you attack back. No, then you can have an imminent danger.
Yeah, it's helpful. I think what you're trying to also confirm, and tell me if I'm wrong, sir, is it's difficult in this situation, like the 9/11 situation, because the threat is from an unseen enemy, right? It's an unseen enemy, so you wait till the enemy becomes seen to be able to take any action.
Kashiana, strictly speaking, it is not in that broader sense. They have tried to use it. This is a preemptive action because you are likely to be attacked. So it is only aligned, I am trying to align with the right to private defense. Actually, the self-defense. It is like a self-defense, not individual defense, but the self-defense of a country. I'll tell you what happened, control. Similarly, there have been very, very, as I told you in National Security Strategy, NSS, it has made it clear that the United States would act unilaterally, to protect its security against emerging threats before they are fully formed. That means the emerging threats on the terrorists, before they are fully formed, the USA has a right to defend its country. So this is not exactly aligned with the right to private individual defense, but for defense of its country. So self-defense is often based on justification of action, what you are taking. Now, some countries like USA, UK, Japan, and Belgium, they have classified as statutory laws under this internationally. And some countries are in the process of, they have given in their laws already they are given. There are anticipatory self-defense measures. They are mostly anticipatory self-defense measures. And international law is also interceptive, I would call it. It's not a defense, but it's interceptive. Before the threat takes place, it's interceptive. The international law also is preventive in a manner. Before the attack, you are preventive. The international law gives them a preemptive self-defense measures to the nations, which can be followed. But it all depends from the state to state internationally. But the statute in the Indian Penal Code that we have, that is right of private defense. You can enlarge it and use it as a right of self-defense for the countries also. The international law is confined to that.
Understood. Thank you. That's very helpful, sir. Maybe, I know we are getting close to our time, but I'd like to have one more quick question, if that's okay with you. And that is, what I would like to hear from you is a very specific example, right? If a person or an offender comes to my property or your property to commit a theft, can I, as the defender, under the right of private self-defense, kill that trespasser?
Certainly. It is provided for in one of the sections of law really mentioned, which I've said from 96 to 106. One section clearly indicates that when this offender comes to take away, then means you can go to the extent where you take away your property, you can beat him, you can threaten him, but up to the death is only if you are threatened for death, if he takes out a weapon. Otherwise, you are certainly going to save your property. You are certainly going to save your own house. You are also going to save your loved one. He comes to attack somebody who is in your house, is your loved one. What is loved one? He comes to attack, you can certainly attack back. But as I told you, proportionate to the offense you expect. That is our counter offense.
Yeah.
But in case somebody comes to have a theft, certainly you have a right of private defense.
Yep. And again, to recap what you said about proportionality earlier, what I'm translating in this example is that there has to be a justifiable, objective belief of imminent threat, not a subjective belief of imminent threat. I can't say, oh, he came and I think that person came in a subjective manner, but objectively did the actions demonstrate or threaten me in a certain way, and then I apply my rights. Thank you. Before we really wrap, do you have any closing quick comments about the topic for our audience, sir?
No, thank you very much. I only want to tell the audience that they should be well equipped with the right of private defense, because society at large today has not sufficient knowledge. In fact, it is a duty of the enforcement agencies itself to particularly educate the society so that their burden is reduced. Today, nobody wants to act because they're inhibited. Oh, if we use something, we may put behind the bar. But make it clear. Have it in a resident welfare associations, etc. There should be a lecture, there should be a talk, there should be discussion, and right of private defense should be explained and led. And also told, all right, you go to this certain place, because people are now wide awake otherwise, but they do not know exact provision of law. And it's very simple. The right of private is a very simple provision of law, and it's there in the Indian Penal Code. My only suggestion is that for the society at large, because of the inadequacy of force, it is very important for the enforcing agencies, for the law enforcing agencies to educate the citizens so that they are able to act and their burden is reduced proportionately. You go to you have some lecture, you have some classes, you interact with the society and make them and apprise them and make them aware of their right of private defense. That's all I have to wrap it up.
Well, thank you. I think what you just suggested is really important, but because, to use the word, it could be a life-changing choice to make as an individual, that I equip myself with the knowledge of what my rights are under the right of private defense, and also know what the limitations are, like you shared. And I want to summarize by saying that self-defense, like Mr. Cpal Singh, you shared with us with your extremely enriching comments, whether personal or state, meaning country, it is a universal concept. The Indian Penal Code suffices and provides in a very simple set of statutes what that means. The right of private defense, however, is not an absolute right. It enables one to be able to navigate dangerous situations, right? Like the examples that you shared, and avoid physical assault. It, however, is not necessarily and not meant to be an offensive right in any way. Is that a good summary, or would you like to add anything?
Thank you very much. Thank you very much. Thank you.
All right. Thank you for your time, sir. Have a good evening. We will talk soon again on a different subject. Thank you. Bye-bye.
Thanks indeed.
Good night.
Good night.